Hi everyone, welcome to the construction law course. Thank you for joining us today. My name is Lisa Marie Edik. I'll be one of the presenters today. I'm a partner in the construction team at Bowmans. My focus is particularly on disputes and claims management in terms of construction contracts, infrastructure projects, and like. And I've been doing construction law since around 2011 and focusing solely on construction law. I'm going to hand over to Diana Berger, who is a senior associate in the team and the other presenter.
Hello everyone. As Lisa Marie just said, I'm Diana Berger, senior associate in the construction team. My focus is both on the front end and back end of the construction and infrastructure industry, specifically in the renewable energy, the infrastructure sector.
Okay, so we don't have a lot of time today, and the aim of this course is really just to give you a 101 on construction law. It's not going to go into the specifics of the different standard form construction contracts that we get. We are more going to focus on just generally how these contracts work, particularly what risks or issues we tend to face in South Africa and how the courts deal with those. And you'll probably recognize some of the issues that we will be dealing with as normal contract law. But for the most part, if you're not familiar with construction law, there will be a lot of new terms that you will learn today. Because we have very little time, I'm going to ask you guys, as and when you have questions, just pop them into the chat box. Diana or myself will answer them as we can while the presentation is going on. And whatever is left or whatever is additional, we'll deal with at the end when we have the Q&A session. Okay, so feel free to just, if you have any issues or any questions, pop it into the chat box. All right, so we are going to just switch off our cameras just because it's a very busy boardroom here, and just to focus your attention more on the slides. You will see that our slide presentation is limited in terms of the categories of issues that we're discussing. After this session, after both today and tomorrow's session, we have already put together a proper book form of course material for you with various references to case law, etc. And that will be made available to everyone afterwards to use as a guidance going forward. All right. Okay, so we're going to kick off with the formation of contracts, specifically the unique nature of construction contracts, and I'm handing over to Diana to take us through that.
Thank you, Lisa Marie. So under contract formation, which is, well, we'll focus on particularly contract law itself, with then just a focus on construction contracts. But under this topic, we'll look at the unique nature of construction contracts, the basic principles that applies to construction contracts, the documents that generally forms part of construction contracts. We'll have a look at the main types of construction contracts defined in the industry. We'll have a look at what usually forms part of the priority of documents, and then I'll just have a quick look at the completion and sectional completion regimes that you find under construction contracts. So in relation to the unique nature of construction contracts, you can ask yourself what is a construction contract and what makes it different from other contracts. a very simple one-liner answer would be that it is an agreement that generally consists of a group of documents between an employer, which is sometimes referred to as a client, and a contractor to construct, repair, modify, renovate, or demolish something. And the important part is that should be in an agreed time frame or an agreed price and to an agreed standard. So we'll discuss those concepts of agreed time, agreed price, and agreed standards later on in the webinar. What is also further unique about the construction contract is it's referred to as an evolving works against a backdrop of evolving circumstances, because breach is always expected on any construction project. And the idea is to manage those foreseeable or unforeseeable circumstances. And that is where we focus on the allocation of risks. In the standard, there's a norm that have emerged in terms of risk allocation between employers and contractors. And the idea is to strike a balance between those risks and obligations between the employer and the contractor by considering which party is better positioned to manage those risks. And the principal drivers for considering the allocation of the risk is time, cost, and quality. And as it's generally these days, it also includes health and safety considerations. Okay, then I'll move on to the basic principles of construction contracts. And I think I've touched on it by way of the definition of a construction contract. Is the essential terms of it is that it needs to cater for deliverable that needs to be delivered within a particular time period and within an agreed price. So it defines the construction contracts can also define or restrict the extent to which the common law would otherwise govern the relationship between the parties. So the first essential element is the what. So you need to define the deliverable. In other words, you have to define your scope of work, employers' requirements or specifications. And the more accurate and clear that is, the less chances you have of facing any dispute regarding that. What falls within the deliverable that needs to be delivered. Then the price obviously needs to be defined, and it needs to be clear what is included in the price. So if the contractor considers the price, it will obviously go and look at what the deliverable is and what the risk allocations are and what risks it needs to carry in the execution of the works or performance of the works. That will include based on what is known at the time and what ought to be reasonably foreseeable to an experienced contractor at the time. So just to give you an example of things that might be foreseeable, or there can potentially be an argument to what must be foreseeable, is if you are a contractor that is performing works in an area where the rainfall in a particular area is in particular seasons quite high, then there's an expectation that that's a foreseeable event and you need to cater for that in your pricing. Then the when. So a construction contract will also define a time for completion of the deliverable based on what is known and what ought to be reasonably foreseeable. Again, the rain is an example for this as well. If you know that rain will fall during a particular period or season when you have to perform the works, that is a risk that needs to be catered for in considering or preparing your program. And then the risks, to respectively allocate the foreseeable and unforeseeable risks, likely or unlikely risks, to each of the parties and provide for effective claims mechanism. We will consider the claims mechanism later on in the presentation. And then construction contracts will also provide for dispute mechanism, and well, first of all, to avoid a dispute, and then otherwise to effectively deal with those disputes. Okay, so then I'm moving on to the document that usually forms part of the construction document or construction contract. It's usually a collection of documents prepared by all the parties that are involved in the project. So it isn't necessarily a document that's simply prepared by the employer and it's provided to the contractor and there you go. Professional team members might also be involved because they've got the technical skills. So the essential documents usually include the construction agreement. That is an introductory document. It sets out the general purpose of the construction document, the details of the parties, what the project is about, and it lists the documents that forms part of the contract and the order of precedence. That will generally then be followed by your general conditions. That is the framework of the construction contract, and it sets out all the rights and obligations between the parties. Your specific conditions, that's a very important document, and from our experience, that document is sometimes just nowhere to be found. But that is generally the additional amendment to the general terms of contract. That's just to tailor the contract for your specific project and what the needs are for that specific project. The scope of work, that is also a very important document to a construction contract. It must be clearly defined, as we've discussed before, because it deals with the deliverable. And I mean, it sets out what the contractor needs to actually do and what it needs to comply with. It has a direct impact on the contract price, and that's another reason why it needs to be clearly defined. And this document is generally prepared by the employer or the client, or it is prepared by a technical advisor to the employer, such as an engineer or an architect or quantity surveyor. Then drawings is also a document that usually forms part of construction contracts. It provides an overview of the deliverable. That is generally a collaborative effort between the employer client and the architect. Then specification or employer's requirements. I think that also speaks to the scope of works. It includes the technical data and performance requirements of the project. It's generally prepared by an engineer or architect with relevant technical skills. Then another important document that forms part of construction contracts is the bill of quantities. It also depends on what type of pricing the parties agree to, but if it's a remeasurable contract, you will find the bill of quantities that sets out an itemized list of the materials, the labor, and equipment that's required to perform the work. And then another extremely important document is the contract construction schedule or program. As I've said, one of the essential elements of a construction contract is the time for completion and the program. So that document outlines all the activities that will be performed. It includes all the planned commencement and completion dates and the sequence of the activities. And that's the document that will be used when there are any delays on the project to assess what the impact of the delay would be. Okay, then I'm going to move on to the main types of construction contracts. So one of the key decisions of an employer when it starts out with a project is to decide whether it's going to use a standard construction contract or a bespoke contract. From our experience, employers usually elect the standard form of contract because using an industry recognized set of terms makes just the procurement process more efficient and competitive. So from our experience, we would usually then just recommend some particular conditions and amendments to the standard form to align with the specific needs of our client's project. So the standard forms of contract that is well known in South Africa is the FedEx suite of contracts, the NEC suite of contracts, the JBCC suite of contracts, and the SAICI general conditions of contract. And then, as I've mentioned, you have your modified standard forms That is just where there are particular amendments to the standard forms. And then the types of bespoke contracts that we generally draft is EPC contracts, engineering, procurement, and construction contracts, where a client requires a turnkey solution and a contractor is appointed to accept the responsibility of the designs, procurement, and the construction. So literally from front to end, and then it needs to deliver the project to the client. Another example of a bespoke contract is operation and maintenance contracts, where an operator is appointed to operate and maintain the project or the deliverable that the EPC contractor produced. Okay, then moving on to priority of documents. So the priority of documents clause, as I've mentioned before, is usually in the contract agreement section, and it provides for the general flow of from the highest priority to the lowest priority of a contract document. And if there is any inconsistencies or ambiguity in the documents, that order of precedence will then determine which document finds precedence. So from our experience, the standard order of precedence is generally the contract agreement, followed by the letter of intent, the letter of tender, the particular conditions, then the specifications and the general conditions, and then the schedules or any other document forms for the contract. Okay, I'm moving on to just have a quick look at the completion and sectional completion regimes. So a construction contract can either provide for a completion date, one single completion date, or sectional completion dates, which means that the project is divided into sections, if you can call it that, and those sections needs to be completed by a particular sectional completion date, following which the section will be handed over to the employer. If that is the regime that's agreed under the project or the contract, the contractor must then plan its program and perform the works accordingly. Sectional completion dates allow the employer or the client to take over the section that it is achieved for its intended purposes. So it then can start up generating power on the one section, for example, if it's a power station, whilst the construction on the other sections can continue. So, I mean, just to give an example, if you look at Medupi, there are a number of boilers. So each boiler could have its own sectional completion date. Once the one boiler is done, that could be commissioned and start up, whilst the other boilers are still under construction. Okay, so then I'm also going to look at the interim payment or the payment regimes under just briefly under construction contracts. And because the contracts are generally lengthy, technical, and involve so many subcontractors, contractors are not in a position to fund the project from the beginning up to the end in order to only receive payment at the end of the project. So therefore, the employer and the contractor generally agree to an interim payment arrangement, which is obviously not in line with the common law. So it's an amendment with the common law where you usually only get payment once the product is delivered. So this interim payment regime is also designed to protect the subcontractor, and it doesn't only protect the contractor in terms of cash flow and to make sure that the project continues and that it can pay its expenses, but the subcontractor that is usually just performing, for example, 10% of the scope of work will be in a position to receive payment of the works once it is complete, and it doesn't have to wait until the end of the project to get payment. Okay, so this concludes the topic of contract formation, and we will move on to contract variation. This is contract variation and not variation orders that you that's a concept under the construction contract. This is just general contract variation. So in terms of our law, oral variations between parties they are enforceable and binding between the parties unless the contract provides otherwise. You will find that the construction contract generally provide for a provision that that says no amendments can take place unless the parties agree and it is put down in writing. So that's the non-variation clauses that is generally found in the construction contracts. There is, however, an exception in terms of case law. A non-variation clause does not necessarily of itself exclude the existence of a tacit or implied term. And we will give a list of case law that's relevant to the topics of discussion that you can have a look at in this on this topic specifically, the Agri Investment, CC and others versus Parayachi of 2019, the SCA is applicable, and the Alfred McAlpine and Sons Ltd, Ltd versus Transvaal Provincial Administration case is also one that you can have a look at. And then other provisions in construction contracts that's relevant in relation to variation is the non-assignment provision or the whole agreement. Usually the rights and obligations of contracts cannot be assigned or ceded without the approval of the employer, and such approval is generally something that cannot be unreasonably withheld. Okay. We are moving on to the next topic of discussion, which is it deals with implied terms, interpretation, and common law. So again, this is more just general contractual principles, but as you would know, this is obviously applicable to construction contracts. So here we'll have a look at the basic principles of contract interpretation based on our courts, what our courts find, and the approach by our courts. We will look at the principle of contra preferentum. We will consider what an implied term is. And based on those topics, we will consider the principles specifically on a letter of intent. Okay, so the basic principles of contract interpretation as found by our courts is that it's a process that needs to be objective, it's not subjective, and contrary to what many people believe, it remains impermissible to consider what either of the contracting parties actually thought the words meant at the time of contracting. So the document needs to be given a sensible and business-like meaning. It must be one that upholds the purpose of the document. So the most important thing that the courts look at is the language that is used, and that remains the point of departure. So, and together with that, so considering the words, the court said that the ordinary rules of grammar and syntax must apply, and it must be read in the context of having regard to the purpose of the provision and the background to the preparation and production of the document. So I'm just going to read out some of the findings by our Supreme Court of Appeals that's relevant in terms of the principles of interpretation. So in Natal Joint Municipal Pension Fund versus Edumeni Municipality, the court held that whatever the nature of the document, consideration must be given to the language used in the light of the ordinary rules of grammar and syntax, the context in which the provision appears, the apparent purpose to which it is directed, and the material known to those responsible for its production. It must be borne in mind, this is held by the court in Shakawa Hunting and Game Lodge, Pty Limited versus Ascari Adventure CC. The court held that it must be borne in mind that in action on a contract, the rule of interpretation is to ascertain not what the party's intention was, but what the language used in the contract means. So, I mean, I know this is probably the contractual principles 101, but these principles are extremely relevant and to construction contracts, and it pops up every now and then on disputes, where there's a debate about a contract provision that's ambiguous and not particularly clear. Okay, then I'm going to just look at the principle of contract referendum. So as you know, any ambiguous term in a contract is interpreted against the draftsman. That's the common law principle. But in construction contracts, it's usually heavily negotiated between the parties. And so it's a joint negotiation and drafting of an agreement. So therefore, there's always a provision in the construction contracts that amend that common law principle to say that principle will not apply in this contract. Okay, then implied terms. The question is, what is an implied term? So a term that is a term that is not expressly agreed between the parties, but contended to be implied into the contract either by way of common law or statute. Now, if you look at common law, our courts have held that it can be inferred by the express terms as a starting point or point of departure, the express terms of the contract, the intention of the parties at the time of the surrounding circumstances, and that the courts always apply the Bayer-Stammer test to ask whether the term is so obvious it goes without saying that if it had been suggested by an outsider at the time of negotiating the contract, the parties would have agreed to such a term. And then in terms of common law, and I mean the Bayer-Stammer test would still apply, but if you think about market-related practices and standards of a reasonable and prudent contractor, a term can also be implied by way of the related practices and standards of reasonable and prudent contracts subject to the Bayer-Stammer test. And then in terms of statute, so even though some of the provisions in the contract may not necessarily address any legislation, provisions of, for example, the Labour Relations Act, Basic Conditions of Employment Act, the Consumer Protection Act, and the National Credit Act will contain provisions that apply in respective agreements, irrespective of whether they feature in the contract itself. And then I just want to close off the implied term section by referring to what Judge Brand held. He said that a proposed tacit term can only be imported into a contract if the court is satisfied that the parties would necessarily have agreed upon such a term if it had been suggested to them at the time. If the inference is that the response by one of the parties, by the Bayer-Stammer question, might have been that he would first like to discuss and consider the suggested term, the importation of the term would not be justified. So if you consider that principle, a court would be very slow to import a tacit term, particularly, and this is in the case of construction contracts where you have concluded a comprehensive written agreement that deals in detail with the subject and where it is not necessary to give the contract business efficacy. Specifically, if you rely on the standard form of contract, because those contracts generally deal with all the aspects that's relevant to construction contract quite comprehensively. Now, considering all these principles that we've just discussed in terms of interpretation and negotiation, I'm going to just briefly discuss the letter of intent. So a letter of intent is generally a letter that's issued when a contractor is successful in its bid to perform the works for a construction project. Then the employer will issue a letter of appointment or a letter of intent. We have been involved in cases where there's been a debate about whether that letter of intent actually constitutes a binding contract between the parties. And it is important to note that the intention of that letter must be very clear. So if it is the intention of the employer that the letter of appointment is not necessarily going to constitute a contract between the parties, it must be clearly drafted in the letter of appointment that the letter does not constitute an agreement and no binding contract will exist between them unless and until the agreement is signed by both of the parties. A defense that can usually be raised in a scenario where a party raises in the implied term is, of course, estoppel. And estoppel can be raised to say that the party must be precluded from relying on the implied term based on the circumstances or the principles that we've just discussed. I'm going to move on to parties. The parties that you would generally find that's involved in construction contracts. Well, first of all, the employer. So the employer is the party that requires the deliverable, and it will, as I've mentioned before, usually set out the scope of work or the specifications it needs the contractor to deliver. The general obligations of an employer under construction contract, and the most important, I would imagine, is to keep access to site and to make payment to the contractor. In some instances, the employer can also be responsible for design, but that really depends on the employer's requirements. The employer can also give the design responsibility to the contractor, as we've discussed before. Okay. Then the contractor, prevention and cooperation. So the employer is always obliged to ensure that there's no interference with the contractor's performance of scope of work, and obviously to cooperate with the contractor in order for it to perform and achieve its obligations under the contract. For example, where an employer has more than one contractor on site, it will generally have the obligation to ensure that there's no interference with the contractor's performance in the scope of work. Then contractor. The contractor will have a direct relationship with the employer and also with any of the subcontractors. The contractor will generally be responsible to achieve the time for completion. And I mean, it has to perform the works according to the standards required by the employer. And in some instances, as I've mentioned before, the contractor can also be obliged to deliver a turnkey solution to the employer. The contractor always have, and that's in terms of common law as well, have the obligation to mitigate any risks on site and any potential damages that the employer may suffer. Then the contractor, as I've mentioned, have a direct relationship with the subcontractors and have the obligation to manage any of its subcontractors. Okay, so moving on to subcontractors. I just want to mention one more thing is with contractors, if an employer has more than one contractor appointed on site, it is sometimes negotiated and legislated in the contract that there's interface and cooperation clauses in those contracts. So the contractors have that obligation to ensure that there is cooperation between the contractors as well, because if you consider risk allocation, that's one of the things that the contractors themselves will be able to manage more appropriately than the employer. Okay, subcontractors. You find nominated subcontractors. Nominated subcontractors are usually nominated by the employer or the client to perform work, but it will still be under the control and the responsibility of the contractor. And there will be no privity of contract between the employer and the subcontractor. The selected subcontractor is a subcontractor that's identified and selected by the contractor and the principal agent. Again, there would also be no privity of contract between a selected subcontractor and the employer. Employers can, however, also appoint direct subcontractors. In that scenario, it's usually where the employer wants the subcontractor to perform a specialist task, for example, dredging or surveying works. And in that instance, there can be a direct contract between them. I just want to mention that in terms of legislation, there are some statutory restrictions on subcontracting. The Preferential Procurement Policy Framework Act states that a person that is awarded a contract by an organ of state is not allowed to subcontract more than 25% of the value of the contract to any other enterprise that does not have an equal or higher B status level of contributor than the contractor, unless the contract is subcontracted to an exempted micro enterprise that has the capability and ability to execute the subcontract. So in subcontracts, we would also expect to see a flow through of obligations from the main contract, because it allows the employer to manage or to ensure that those obligations are complied with by the subcontractor. In some of our contracts, you would also find equivalent relief provisions. So that means where a contractor had a claim against the employer that is corresponding with any claim that the subcontractor may have against the contractor, the subcontractor's relief will be limited to the relief that the contractor recovers from the employer. Employer's representative. So I'll quickly run through that because we're going to discuss that as a separate topic as well. So the employer's representative is also, as you know, involved in the construction project, and it's an agent that acts on behalf of the employer. Although the party is mentioned in the construction contracts, it's not a party to the contract itself. The employer's agent will have a separate contract with the employer. It's usually an engineer, a project manager, quantity surveyor, or an architect. It does sometimes feature that there's an in-house appointment for the employer's representative. So the general responsibilities of an employer's representative is that it needs to act as a skilled professional. And you may see in the construction contract that it's generally obliged to certify payments, to make the determination of claims, issue instructions in relation to the works. And the reason for that is just because it's got that professional technical skills, and which the employer doesn't necessarily have. And then again, although it is an agent of the employer and receives payment from the employer, it still has an obligation to act independently in the interest of both parties. Although from practical experience, our clients have told us that sometimes they do find it challenging, because although there's an obligation that the employer's representative needs to act independently, it is incentivized to act in the interest of the employer, which is obviously not supposed to be the case. Then I'm going to look at the professional team. The professional team is generally involved in the project long before the construction contract is concluded, because they are involved at the stage where the employer starts to create the concept of the project, and they do the designs, they work on the costing of the project. So that the professional team will also then, as I've mentioned before, usually consist of the engineers, QS, project manager, etc. Okay, and then I'll move on to our next topic, slides. Okay, agency and professional team. Okay, so I've just said that the professional team usually consists of those professionals. I'm going to consider the agency principles briefly. So usually an agent has the actual authority to act on behalf of the employer because that authority is created by the agreement that's concluded with the employer. There's also ostensible authority, or what is sometimes referred to as apparent authority, which comes from custom or market practice. But there are exceptions to ostensible authority, and that is when there are express provisions that restricts the professional or the agent's authority. So usually ostensible authority is a legal relationship that forms between the parties, and it arises from where there's a representation of authority to contract on behalf of the principal. So in this case, it would be to contract on behalf of the employer or the client. The representation is intended to induce the third party to rely on it. And the third party was induced and relied on it. It actually relied on it. So, and then the principal appeared to confer authority on the agent. So in circumstances of a construction contract, those principles will definitely apply, particularly in scenarios where the employer's agent certifies payments and makes determinations, issues variation orders. There are however provisions in construction contracts that we've seen where the professional agent is specifically excluded from, or its authority does not include, for example, the right to make amendments to the contract. So yeah, that's interesting to see that sometimes they do actually provide for specific circumstances where the authority is restricted. Okay, then just to move on to the standard contracts of appointment for professional team. The contract that's most familiar in South Africa is the PROXA and the FIDIC White Book. From our experience, the PROXA contract is very employer friendly. So, I mean, usually both those contracts will in any event be amended by particular conditions that is tailored for the specific project. The term and duration of professional agent or of a professional team, it's generally linked to the duration of the project. It may even be longer because, as I've said before, they're usually appointed long before the construction project commences. So the contract usually has an expiry date. And what is important to note is that the professional team usually gets so involved in the project that they completely forget about the duration of the project and expiry date, and find themselves in a situation where they've performed works long after the expiry date. And when it comes to payment day, the employer simply says, well, I'm not going to pay because your contract has expired. So I just want to focus on, to put all of your focus on that, and because that's something that needs to be, yeah, I think brought to everyone's attention, specifically if you're in the services industry. Some of the contracts also have an automatic renewal provision, so that the term of the contract can be renewed after a particular period. Payment terms, the general payment terms that you find in these contracts, and they're usually time-based or project cost-based. And so if it's time-based, it will be an agreed hourly rate. If it's project cost-based, then it will usually be an agreed percentage of the construction cost. Also, I just want to mention that some of the professional fees are guided by legislation. So, for example, the Architecture Profession Act of 2000 provide guidelines for professional fees. The functions of the professional team, as I think I've mentioned that briefly before, is just to issue notices and communication generally, issue instructions to the contractor, be responsible to measure and evaluate the works performed by the contractor, further to evaluate claims and issue determinations and certify payments to the contractor. And the scope of work is obviously aligned with that, including more generally the project management, cost management, design, and doing analysis of site conditions, be responsible for program management, cost estimates, etc. The professional or employer's agent also have a common law duty of care towards the employer. And the standards of the service that is delivered is usually measured against the reasonable and prudent service provider with a level of experience, or a particular level of experience. So, and then another provision that we usually see in the employer's professional team's contract is professional indemnity insurance. And in this instance, there will usually be a requirement or obligation for the professional to obtain and maintain the insurance for the duration of the project. And usually it must be for a value of 2 to 3 times the fees payable to the professional. And the employers would require that that insurance be procured from a reputable insurer. And also, the employer would require documentary evidence that the insurance is in fact procured. It can be sometimes a condition precedent to the professional agreement, services agreement. Okay, then copyright. Copyright is an issue that or topic that's generally featured in the professional team's contract. You will usually see the provision that intellectual property and copyright of materials are assigned on an irrevocable and unconditional basis to the employer from the date that it's created and the professional received payment. Pre-existing intellectual property usually remains vested with the professional. Okay, I'm going to move on to pricing.
All right, so I'll be discussing the scope of work with you. So the scope of work is probably the most important part of any construction contract, irrespective of what the type of work is. So when we talk about a scope of work, what is really meant by that is that it should be a written document which outlines what activities will be included in your construction project. It'll form part of the contract document, and it'll describe the project's objectives, any milestones, deliverables, and outcomes. So the scope of document basically lists the construction obligations and the work activities that the contractor and the subcontractors, as well as any suppliers, are obliged to do in order to complete the project. So a good scope of work will include a project overview, which is a summary and a description of the project, and also a highlight of what the main objectives are. It'll give a project scope, and that kind of just sets out the goals of the project. It includes quantifiable data, a budget, as well as technical specifications of the work that needs to be done. It's also the document in which to list all the different milestones of the project. It'll include project deliverables, as we said, being the objectives and the targets for the project. It typically has to be linked to a project schedule or a program, which is a timeline for all the work activities and the interface activities as a complete breakdown. So on your project schedule, you'll have to indicate what the critical path of your activities are, as well as different delivery dates, interface dates, and an overall completion date, or where there's sectional completion dates. Lastly, it'll include project management scope of work. That will be completed generally by the employer in consultation with the project management team. And it'll include payment information, legal requirements, and sometimes it'll also include changes to the original contract. So I know that we have got a few people on here who might at some stage or already have acted as a project manager. So when you are asked to help draft a scope of work, typically we use the SMART model, and that just means it has to be specific, it has to be measurable, it has to be achievable, it has to be relevant to the goal of the project and the goal for the employer, and it has to be timely. If you use this model, you would probably avoid, or to a large extent avoid, future variation orders or changes to the scope of work. And we'll talk about that a little bit later, but those types of variation orders could lead to overruns on the budget and unnecessary delays. So the question is then, why do we have the scope of work? And the answer is simple. It gives absolute certainty of what is expected from the contractor at any given time during the project. It also provides certainty of what the end product will be that the contractor must provide to the employer. The more uncertainty there is in the scope of work, the more disputes, the more delays, the more budget overruns. So if a scope of work is well thought through, well drafted, it'll avoid all of these risks. And it is probably one of the most important project management tools that you need to get right up front. Then we have, as part of the scope of work, we have specifications, and these come in various forms. So we can have prescriptive specifications, and they kind of deal with details of, for instance, the types of materials or the brand of materials that need to be used. You've got performance specifications focusing on the operational requirements of a project. What is it that I want my end product to be able to do? And then we've got proprietary specifications, which is often used for a single type of project or any kind of installation or job involving existing equipment and already completed installation. So that's where your scope of work has to fit in with existing equipment and installations. So specifications are included to ensure that the contract builds the deliverable according to specified materials, finishes, and standards. This obviously enables everyone to understand and to ensure that what is built ultimately will be fit for purpose. It details the work, the workmanship, and the methodology of work, as well as the quality that will ultimately be required. When we look then to a change to a scope of work, so as we discussed early on, a construction contract is very fluid, and we can often expect to have changes to the scope of work. The problem with making changes to the scope of work as the project progresses is that it can have an effect on the time. So if there's a delay to the critical path, which we'll discuss a little bit later, but if there's a delay to the critical path, it will impact the overall completion date of your work. It can have an effect on the cost. So either more time is spent on the project, which means more cost for the contractor that they can ultimately claim from the employer. It can mean that additional resources might be required, which will also increase the cost. It can mean a cost of additional materials, additional plant, equipment, safety, PPE, etc. Further, it can have an effect on the sequencing of work. Now, we discussed a little bit the program or the schedule, and as we said, it sets out the sequence of activities that you find in these construction projects. And a contractor would sit when it tenders for work or when it prices the work, it'll work out the most efficient sequence of work, sequence of activities to obviously be most cost effective. When you change the scope of work, that new work has to be slotted in somewhere into that schedule. And ultimately, it can have an effect on the sequencing because the contractor might have to completely resequence their work, or they might have to first suspend some work, do that work, and then continue with the previous work. This could all lead to lower productivity. It can lead to delays and inefficiencies. And then lastly, the effect on sequencing could also lead to longer hire of plant and equipment. So for instance, where you have really massive cranes, generally a contractor won't have those as part of its assets. It would have to hire those in, and it hires on certain terms for a fixed period. So it could then affect how long that hire agreement or rental agreement must continue for. All right, then the additional risks associated with a change to the scope of work is health and safety issues. As we all know, these projects are quite intensive when it comes to requirements on health and safety, and each type of work that you do might have different health and safety rules and regulations. It can have an effect on the actual safety and security attached to the additional work. So where a contractor has got the obligation to keep its site or its project while it's working on it safe, and the employees working on it safe and secure, they might now have to make changes or bring in additional safety and security measures. It can have an effect on design and specifications. It can have an effect on supply. So especially for long lead items, those types of items are generally already ordered and paid for up front because, or not necessarily up front, but long in advance because the contractor knows that it'll need it by a certain time. If the change in scope includes the procurement of long lead items, all of a sudden your program might be suspended or your work activities might be suspended, and you might find yourself first waiting for long lead items before you can continue your work. It can lead to waste or double work. So for instance, if you'd already done a portion of the work and you now have to either break that down or redo it because that specific work has already changed, that will lead to waste or double work, and it mostly does lead to disputes. And the question on the disputes is, what triggered the scope of work? Is it because there was a design flaw that had to be rectified for which the contractor is liable? Or is it because the employer didn't get their scope of work right from the start? That's just an example. So disputes are quite regular in terms of changes to scope of work variation orders. Okay, so what happens if your contract does not provide a mechanism to change the scope of work? So you've agreed with the employer as a contractor what you need to deliver, but now your contract doesn't really provide for changes to that deliverable or to the scope of that deliverable. And the answer lies in the common law, and a contractor is not obliged to perform any work which does not fall within the contracted scope of work. So that just means that an employer has no implied right to vary the works and the contractor has no implied obligation to comply with such an instruction unless there's a mechanism through which that change can be effected and certain remedies are attached to it. All right, and then I just want to go just slightly more into detail on the program of works, which is often also referred to as just as a schedule. So you've got what's called an agreed program. Generally, that's a term used, or it would have a defined capital P program. And then you have what is called a works program. And the difference between the two is quite key from an entitlement perspective. So an agreed program is the program that the parties agreed on in relation to the scope of work at the time when the contract was signed. So as and when there are changes agreed to the scope of work, or there are extensions of time, or changes determined by the project manager, the agreed program will then be updated and it'll override the previous one. So this is the program that sets out how the work should be progressing in order for the contractor to be able to meet the completion date. And this is the program that will be used to ascertain whether liquidated damages should apply. We'll talk about that a bit later. Alternatively, whether the contractor is entitled to an extension of time based on critical path delays. When you talk about a works program, that's more a management tool. So it's generally kept by the contractor, but it's used by both of the parties as a project management tool. It's not binding on the parties in the sense that it changes the agreed program or the completion date. It's rather used to determine any risks of delay and to assist the parties in identifying mitigation strategies where the work is falling behind the program. So this is really just a contemporaneous program of how the work is actually progressing against the completion date. All right. So there you've got a very simplified schedule or program on one of the project management tools that parties use. And you'll see there's stages of work. Each stage of work is broken down into activities. And next to the activities, you'll see bar charts, which just shows you how long an activity should take or is planned to take. And there you'll see some activities run concurrently and some activities can only start once a previous activity is done. All right. Okay, so then we move over to risk allocation, including indemnities and limitation clauses. So risk, and there you'll see we've said often parties have this problem. We've considered every potential risk except the risk of avoiding all risks. So that's typically what happens in construction contracts that we see during negotiations. Instead of properly allocating risk, the parties are trying to avoid all the risks, and you can't. Construction contracts by nature has got risks, which is unavoidable and which is actually anticipated. And the best way to deal with those is to properly allocate them to whoever is best placed. So risk involves uncertainty about the effects or the implications of an activity. When it is said that a party bears the risk, it simply means that a party will carry the consequences of the risk event occurring. So construction risks are categorized as contractors' risks, employers' risks, and then neutral or shared risks. So it's a major element in the construction industry, as I've just said, which can affect completion and it can affect costs. And so it's important when you deal upfront with risks and you properly allocate it, the consequence of that would be that it would be properly priced for if it lies with the contractor, or there would be proper mechanisms to mitigate it or deal with it as it arises if it lies with the employer. So There are many risks which we find to be market or sector specific, as well as specific to certain jurisdictions. And the key with dealing with those is to firstly understand the risks associated with that market or sector or jurisdiction, and then to manage it through contract mechanisms that work for it, rather than to just try and avoid it or just try and give it over to the other party because you don't want it. Okay, so when we talk about specific risks, there are specific risks in the South African market, which we've seen having caused major disputes just because the contracts didn't deal with these risks and the parties simply hoped and prayed that somewhere in the standard form contract that they're using, these risks would be allocated somewhere. So these are labor disputes and strikes, particularly because it often involves violent behavior, which leads to site closures. For instance, in 2000, I think it was 2012 to 2014, around there, we saw the Medupi Power Station site closed at stages for 6 months on end because cranes and offices and cars were being burnt down, and it was just unsafe for people to return to site. And of course, we all know that the main reason for that is because those types of issues weren't properly anticipated up front. It wasn't properly dealt with through labor practices when it happened, and ultimately a lot of lessons were learned through specifically that project. We then also have the construction mafia, and we'll talk a little bit more about that later on, which is just colloquially, we can say they are extortionist groups. Then we have fluctuations in exchange rate, obviously heavily relevant for South Africa. And we've got delays in procurement. Again, firstly, it can be international issues. A few years back, well, not even a few, maybe maximum 2 years back, we saw China being load shedded, which heavily impacted on the renewable energy programs because solar panels couldn't be imported. But more specifically to South Africa, we might have issues with ports, we might have issues with transport, and we might have issues with import taxes, all due to local issues that come and go from time to time. Other common risks that you would find that need to be properly provided for in the contract is environmental concerns, financial requirements, costs, design errors and emissions, defects, issues with access to site, how to deal with additional work, as we've just discussed, delay in performance, health and safety issues, sorry, I already dealt with that, decreased productivity, geotechnical conditions, force majeure, and then your things that often, well, that we don't really see in South Africa, war and similar events. All right, so when we talk about risk allocation, it's really a term used to say that it's important to understand the business of both the employer and the contractor, the goals that the employer has with the project, and the abilities of both parties. Once you understand those things, you can properly allocate the risk to a party that's best placed to control and absorb that risk. Where there is a proper allocation of risk, it influences the behavior of the contracting parties, that they know that there's certain things that they are going to have to stand for, and it just influences how they behave and how they mitigate and manage those risks. Properly allocated risk can also lead to good performance and to keep your costs within the budget. So it also informs your construction methodology and the process that a contractor uses to complete their works. Now, there's various ways in which you can mitigate risks. So we've got the allocation, but then we also have some form of mitigation of risks for both parties. So it can be either through indemnities, it can be through limitations of liability or exclusion clauses. And then we'll deal with those in detail, each of them in detail. And it can also be mitigated through insurance. When we talk about mitigating risks through indemnity, that means we are going to include some indemnity clauses where one party agrees to make good a loss suffered by another party. It can be expressed to apply to liabilities occurring either before or after the date on which the indemnity is given. And the most common indemnity that we see, not just in construction contracts, but probably in most contracts, is one where a contractor indemnifies an employer against third-party claims for damages, losses caused by the contractor or its employees. So the mitigation, this mitigates the risks of an innocent party for which it cannot contract in an alternative manner. For example, an employer cannot use an indemnity as a defense against a claim by a third party for damage suffered on its site. But what it can do is it can rely on that indemnity clause to then transfer the claim over to the contractor. Then mitigating risks through limitation of liability or through exclusion clauses. So this is where we provide a limit or exclusion of a sum recoverable by an innocent party for the liability of another party. And the most common exclusion, again, across all contracts is probably excluding consequential losses. So this really mitigates the party's risk of monetary liability for certain events. And the parties accept that they would not be able to recover certain losses from the other, or that they would be able to recover only a portion of its losses from the other. The limitation of liability would be enforceable against the contractor for any work done by subcontractors and employees, insofar as they directly subcontracted and the scope of work is included in the scope of work under the main contract to which the limitation of liability is applicable. But, and we'll talk about this when we deal with subcontracting, it is still important for a contractor where he wants to transfer these types of limitation and exclusion clauses to properly deal with those in the subcontracts. So typically, an employer cannot claim additional damages directly from a subcontractor because there's no contractual nexus between those parties. And so the only recourse an employer would have is against its contractor. Of course, that doesn't mean that the subcontractor would be, as I just said, bound by the same limitation of liability unless it's specifically dealt with in the subcontract. Then the question really is, and has been in our courts in various cases, whether you should actually be upholding these types of limitation and exclusion clauses. And generally, we follow the principle of pacta sunt servanda, which means that agreements can be freely and voluntarily concluded and the terms must be honored, irrespective of how unfair they might seem or how unhappy a party might be subsequent to it. There's self-autonomy when we contract, and we have the ability to regulate our own affairs, even to our own detriment. And that's the very essence of freedom and a vital part of dignity, as set out in Barkhuizen versus Napier, which is one of the leading cases on this issue. The exception to this and the basis upon which a court will not uphold a clause such as limitation of liability or exclusion clauses is considered to be where that clause is against public policy, in which case the court won't uphold or enforce a specific clause. So how public policy as a basis upon which a court might refuse to enforce a term of contract should be determined requires an inquiry into the social policy and the normative content behind the common law rules that inform our judicial control of contractual terms on the basis of public policy as evidenced by the constitutional values. So as I said, Barkhuizen versus Napier is also a very good case to look at this, and we'll discuss another case in a moment. So the first stage that a court would follow when it considers whether or not to uphold a clause is looking at the clause itself. So the question is whether the clause is so unreasonable on its face that it is contrary to public policy. If the answer is yes, the court would obviously strike down the clause. If the clause is not found to be that unreasonable, then the second stage of the inquiry would be whether in all of the circumstances of the particular case, it would be contrary to public policy to enforce the clause. The onus is then on the party seeking to avoid the enforcement, of the clause to demonstrate why its enforcement would be unfair and unreasonable in the given circumstances. A court should, however, exercise its power to refuse to enforce a contract on the basis of public policy very sparingly and only in the clearest of cases. So in one of those cases, the Artica 231 and others versus trustees for the time being of the Oregon Trust. And as I said, you'll get access to all of these cases. This is a 2020 case. The court said the following about excluding liability for willful misconduct and gross negligence. In no circumstances can a party exclude liability for loss or damages resulting from its fraud or dishonesty. On the grounds of public policy, the law will not recognize an undertaking by which one of the contracting parties binds himself to condone and submit to the fraudulent conduct of the other. The courts will not lend themselves to enforcement of such a stipulation, for to do so would be to protect and encourage fraud. In Algen Brown versus Harmer, Algen Brown and Harmer versus Industrial Machinery Suppliers, the court confirmed that a party cannot exclude liability for loss or damages arising from its own willful or deliberate misconduct. In some cases, the exclusion of even gross negligence can be found to be contrary to public policy, although such exclusion clauses would generally be upheld. So you can look at the Government of the Republic of South Africa versus Fibre Spinners and Weavers, where the court found that there's no justification for restricting the plain meaning of the words of the exemption clause, nor is there any reason founded on public policy why it should be held that insofar as the clause refers to loss or damage caused by the defendant's gross negligence, it is not enforceable. In the case of CSAR versus Addington, the court found that a party is not exempted if he displays gross negligence or malfeasance, or if he employs such servants as are likely to be guilty of gross negligence or misconduct. So you can clearly see that whether or not an exclusion of gross negligence will be upheld will depend on the specific circumstances around each case. So the court's approach to upholding limitation of liability clauses, firstly, looking at the common law, it has to be considered when assessing the validity of an exemption clause. The courts weigh up a party's right to freedom of contract against public policy considerations yet again. One of the leading cases there is Freddie Hirsch versus Chickenland. And the court provided that a clause in terms of which a supplier attempted to exclude all conditions, terms, warranties, or representations as to quality, fitness, performance, or otherwise in relation to the goods was unenforceable as it was completely contrary to public policy. The court also provided that a clause in terms of which a customer indemnified the supplier against all claims, loss, damage, expense or proceedings of whatsoever nature against or on the part of the company for whatsoever reason was unenforceable because the indemnity was so gratuitously harsh and oppressive that public policy could not tolerate it. Okay, so that is then dealing with exclusions and limitation clauses. Moving over to mitigating risk through insurance. So you will always see provisions in the construction contracts dealing with which party has to take out which insurance. And insurance cover is really just bought to neutralize or to reduce the consequences of the insured risks. And the risk stays with the party to whom the risk is contractually allocated, regardless of who takes out the insurance. So if the employer is contractually responsible for taking out insurance to cover the works, and a risk materializes that causes damage that is not fully covered by the policy, the contractor will still be liable to compensate for the balance of the damage caused. And that's just very shortly what that is about. Okay, so we're going to move over to deal a little bit more in detail with subcontracting. So Diana's already mentioned the different subcontracting regimes. And we'll just look at subcontracting overall and what that means within the South African context now. So who is a subcontractor? It's a party outside of the main agreement, contracted to perform a specific portion of the main contractor's scope of work. And they are contracted sometimes directly by the employer, but mostly through a main contractor. All right, so what is the reason for subcontracting? You might need a specific skill that your main contractor or that the main contractor doesn't have. You might need additional resources. It might be cheaper for the subcontractor to do it, that portion of the work, than for the main contractor. There might be local content requirements, and there might be BEE requirements. So between the employer and the contractor generally assumes the full responsibility for the performance of all the subcontractors. However, this position can be modified contractually so that the employer assumes certain risks of the subcontractor's scope of work. Ultimately, the risk regime, how it's allocated, will depend on whether it's a nominated, selected, or a direct subcontractor. A contractor is then entitled to an additional amount for attendance and profit where it appoints a subcontractor. And where it does so, the subcontract agreement, it's very important to understand, is separate from the main contract. And they need to work well with the main contract. That means you might need certain pass-through provisions, which we'll chat about a bit later. You have to properly allocate liabilities and deal with limitations of liability to fit with what the contractor's liabilities would be under the main contract. You need to make sure the scope of work is properly defined. You need to have payment provisions which work well with whatever payment regime there is under the main contract. Same with the notice provisions, and same with dispute resolution mechanisms. Also important to understand, as a contractor or as part of the legal or professional team helping an employer or a contractor put together a structure for a project, is that when you're dealing with local government and even some of the privately owned companies, there might be certain very specific requirements for subcontracting, which includes BEE, it includes local content, and the Preferential Procurement Policy Framework Act might also be applicable together with the preferential procurement regulations. So always be aware when you're drafting your subcontract or choosing your subcontractors that you have all the details and understand what you need to subcontract out. All right, then moving over to privity of contract. So there is no privity of contract between an employer and a subcontractor. However, it is common practice to reference the main contract when you draft your subcontract and to incorporate the terms of the main contract by reference insofar as it relates to the subcontractor's scope of work or any rights and obligations that the subcontractor takes over from the main contractor. So again, it remains a separate agreement, the subcontract and the main contract, but you can incorporate the main contract. And you can also, in your main contract, draft for certain direct links of liability, rights and obligations between the employer and the subcontractor. Okay, so then we are going to consider pay when paid provisions, which is obviously a very sensitive issue. So the relationship between the contractor and the subcontractor is subject to negotiation, but it is usually managed on a back-to-back basis with the main contractor, as I've explained. So, for example, a contractor is free to request an indemnity from the subcontractor, which will typically be on the same or the similar terms as that provided by the indemnity provided for by the contractor to the employer under the main contract. So in addition, the back-to-back arrangement often extends to a subcontractor's right to receive payment. This is referred to as a pay when paid clause. And that really just stipulates that the subcontractor will only be paid once the main contractor has received its payment from the employer for that portion of the work. So, for example, in England and Wales, the pay when paid provision is not enforceable, but unfortunately it is still permitted under South African law, and it is used fairly often, if not always. But these conditional payment arrangements are frowned upon in the industry because it often results in relatively small stakeholders being cash-strapped, especially when there's disputes about payment between an employer and a main contractor. So in May 2015, the Minister of Public Works issued a notice of intention to amend the Construction Industry Development Regulations, which is published under the Construction Industry Board Act, to include what was referred to as prompt payment regulations. And those were aimed to prohibit conditional or pay when paid clauses in the contracts, to prohibit the withholding of payments and requiring regular progress payments within defined timeframes, to introduce the right to suspend construction activities or performance non-payment, to introduce the right to charge interest on late payments, and to introduce a mandatory statutory form of adjudication for resolving payment disputes. Unfortunately, these draft regulations were not really well drafted, and after consultation with various stakeholders, it was ultimately withdrawn in October 2017 due to concerns with constitutionality. And unfortunately, it has also never been revisited. Okay, so another back-to-back type clause, which is used fairly often, is referred to as a pass-through claims provision. And this is just where a subcontractor is only entitled to receive compensation for claims insofar as the contractor received compensation for that claim from the employer. So how it typically works, when you're a subcontractor, you have your own mechanisms and regime for claiming, let's say, extension of time and additional cost. You give your notice to the contractor similarly gives notice to the employer. You give your particulars of the claim to the contractor, and depending on whether the contractor has additional costs, it either adds its own additional costs or it just moves your claim straight on to the employer. Now, what these pass-through provisions usually do is they say the contractor will do everything that it can to ensure that you have there's a successful claim against the employer. But if the employer rejects that claim, then unfortunately the subcontractor's claim is going to be rejected under the subcontract as well. Now, of course, this creates many challenges and possible issues if it's not well drafted. So we have, through lessons learned and drafting many of these types of clauses, learned how to properly deal with those pass-through provisions, how to make them work, how to make them fair, and how to make sure that the subcontractor isn't just left to its own devices and at least has some say in what happens to its claim. But if it's not well drafted, these types of clauses could be a real problem for a subcontractor. All right, and then dealing with direct payments from the employer to the subcontractor, and this is particularly where a contractor gets paid by employer, but they don't pay the subcontractor. The subcontractor runs to the employer and says, I'm going to stop my work because I'm not being paid, and I want you to pay me directly. So in terms of common law, where there's no specific provisions in the contract dealing with direct payments between employer and subcontractor, it just provides that where the subcontractors execute certain parts of the work, the contractor will be liable to the subcontractor for payment in the same way that the employer is liable to the contractor. As there is no privity of contract, between the employer and subcontractor, the subcontractor is not being paid by his contractor, has no recourse to the employer under the common law. However, we do see sometimes the employer nevertheless agrees to make direct payments, and it's often because they just trying to save the project and they don't want the subcontractor to stop the work. But that has got its own consequences and risks which lie then with the employer. So the effect is that there might be a possible double payment by the employer. So if they choose to pay the subcontractor directly, rather than to pay the contractor and leave the contractor to manage their own subcontract, that does not mean the employer can then relieve itself of paying the contractor for that portion of the work. Because the obligation arises under the main contract, the employer will then still have to pay the main contractor for that work as and when it's claimed, and then have a double payment because it's already paid the subcontractor for it. So the employer runs the risk with that. And we must keep in mind that although it might seem to be a very simple tool to ensure that subcontractors get paid timeously and to assist subcontractors with cash flow, etc., there are other considerations which we shouldn't lose sight of. And that is that an employer shouldn't interfere with the relationship between the subcontractor and the contract. So the contractor might have a very valid defense under the subcontract for not paying the subcontractor for that specific portion of work. There might be pending disputes, there might be defects, there might be various reasons or valid defenses against not paying. And where the employer then goes and makes payment directly to the subcontractor, it's interfering with those contractual rights, which the contractor has got. All right, so that is then subcontracting in a nutshell. And we are moving over to pricing, which Diana will take you through.
Okay, so I will just quickly go through the different pricing options that you find under construction contracts generally. So the first option is the lump sum or fixed price contract. And what that is, it is just a single lump sum price for the project, and is determined before the works actually commences. So the intention is to include all the risks and obligations in that pricing. So generally, there's a higher threshold of risk allocation on the employer. This option is appropriate where the works are well defined at the time that the contractor actually tendered for the work, and there's a low likelihood that the employer's requirements will change. The advantages of having a fixed price contract is that it creates simplicity and certainty to the employer and the contractor. The contractor does not have to be concerned about justifying the price of any of the work within the scope of the contract. Although the price may alter during the carrying out of the works, example due to variations or the occurrence of certain relevant events, the pricing option tends to give the employer a reasonable amount of price certainty. The disadvantage is, however, to the employer that due to the risk allocation on the contractor, the price is likely to be higher. Cost plus contracts is the alternative option. That is where the contractor is reimbursed for the actual costs that it incurred in carrying out the works. So, for example, the labor, the plant, the materials, the subcontractors, etc., plus any additional fees to cover its overheads, and then obviously it will also include profit. This option is generally appropriate where the scope of work cannot be well defined at the outset, but the employer nevertheless requires an early start on the site. The advantage of this pricing option is that it provides more data for an institutional owner to give to its board or committees in budgeting and planning capital improvements. The disadvantages are that the contract is typically entered into on the basis of an estimate of the cost only. They are generally a high risk for employers, and for the employer, the uncapped nature of the cost plus arrangement opens it up to open-ended construction costs. The cost plus contracts are often heavily negotiated in order to accurately and thoroughly determine the risk and cost allocations to the contractor and the employer. Then the other option of pricing is unit price or remeasurable contracts. And that is where the price for the works is not determined when the contract is entered into. It is generally calculated based on the remeasurement of the actual work carried out. So the remeasurement calculation is undertaken using the agreed rates or the unit prices, which is generally set out in the bill of quantities as provided by the professional team or the contractor. The advantages of, or the advantage of this is that it's suitable where there's a lack of certainty as to the volume of the work that's required. Even though the design, specification, and quality requirements can be reasonably well defined at the 10 stage. And the disadvantage is that as the total cost of the work is not determined at the outset, the employer tends to carry the greater risk under a remeasurable contract. And then I just want to touch on a few pricing terminology or terms that generally features in construction contracts. So prime cost items, those are the items that's not selected or of which the price is not known at the time when the contractor needs to provide a price. Then provisional sums, that is an allowance or a best guess estimated price of an item that are not yet well defined in order for the contractor to price it accurately. Then you also get contracts that's performed based on task orders. And for each task order, there will be a separate price. Milestone payments is the regime that you also often find under, that doesn't necessarily deal with the pricing itself, but it sets out the milestones when the contractor receives payment. So, and it only receives payment once that milestone is achieved. So, for example, the first milestone can be the receipt of materials, the second be the transport and delivery of materials to the site, the manufacturing completion, installation completion, etc. And then another concept that you find in the construction contracts is price adjustment clauses. That just caters for cost escalation risks as the price established at the date of the tender remains subject to escalations. So yeah, that concludes the topic on pricing.
All right, then we're going to talk about securities, which is going to take me a long time because it is a very big bone of contention always. And I have plenty to say about this. So I'm going to go through it as quickly as possible. Just bear with me. So in general terms, there are three main types of security against construction risks. Those are contractual forms of security, such as delay, liquidated damages, performance liquidated damages, retention money, etc. There are insurance policies, and then there are security instruments issued by third parties, such as guarantees, bonds, and letters of credit. In most cases, all three of these types of security will be adopted as part of the risk management strategy for a project, but the level and value of the security will vary depending on the nature and the complexity of the project, the financial standing of the parties, pricing, commercial considerations, as well as market practice. Typically, the types of security provided to an employer by the contractor would be an advance payment guarantee, a performance guarantee, a parent company guarantee, and those are security instruments only. An advance payment guarantee is typically an on-demand form of guarantee to secure the employer against the repayment of any advance payments made to the contractor. So advance payments are ordinarily made, especially where the contractor has to fork out money to establish site, or get long lead items, procure long lead items, etc., where the contractor just doesn't have the money to have that initial startup. Then there would be advance payments. So as I said, this is typically an on-demand guarantee. And it's given because although advance payments are repaid monthly through withholding a portion of monies due for work done, it sometimes does happen that the contractor is cash strapped, and the employer then agrees to delay the repayment of advance monies until a later stage in the project. At that stage, there might not be much value left in the work to be done, and the employer then might not be able to recover the full advance payment through withholding monies due for work done. And so if the contractor then doesn't pay the full advance payment, there's this guarantee to fall upon. Performance guarantee, also on-demand guarantee, typically drafted widely to secure the employer against any form of breach by the contractor. So this should be given by a reputable bank or financial institution, and an employer should check when it gets a guarantee that it is from a reputable bank or financial institution. A performance guarantee typically has an expiry date, which is linked to either the original date for completion of the work or a final completion after a defects notification period, whereafter the security is then released back to the contractor. Where the completion date or the DMP is extended, and if you're a project manager, listen, please, where the completion date or the DMP is extended, the expiry date under this performance guarantee has to be extended likewise, because you cannot enforce the guarantee after its expiry date. The guarantor will have no obligation to pay after the expiry date. And so you'll find often in the standard form contracts, there's a requirement that 28 days or 2 months or whatever before the expiry date is due to happen or to occur, the contractor must give a new or an extended performance guarantee. Parent company guarantee. So this is given by one contracting party's ultimate or intermediate holding company in favor of the contractor to secure the performance of the contractor's obligations under the contract. This is particularly useful to secure the contractor's obligation to pay compensation following an employer's claim or early termination of a contract, where the sums involved are likely to be substantial and the parent company has a better bank balance than the contractor. They can be drafted as conditional or on-demand guarantees, and we'll discuss the difference between the two. Where they are conditional, they're akin to a suretyship, and they create an accessory obligation, which is an obligation independent on the existence or coming into existence of a valid and effective principal obligate, not dependent on the existence or coming into existence of a valid and effective principal obligation. So it is linked to the underlying contract, and a breach of the underlying contract must be proved before a guarantee that is conditional can be enforced. We'll look later at how on-demand guarantees differ significantly from this. So the central provision for a typical PCG is that which gives the employer the ability to recover from the guarantor all losses and expenses which the employer incurs or will incur as a result of a contractor breach or insolvency. And it contains an option for the guarantor to make good any defects in the works themselves. But as with a performance bond, the guarantor is expected to pay the employer the losses it suffers as a consequence of the contractor's breach of the construction contract. Retention money is a percentage of payment due for work, is the percentage of the payment due for work done that is retained monthly or at regular intervals by the employer up to a maximum percentage. So maximum percentage value of the value of the work. This amount is shown on the payment certificates that's issued, and the employer usually withholds the full cash amount until at least practical completion or takeover, as we call it, when typically half of the amount would be released back to the contractor. The other half, however, is then kept by the employer until until there's final completion, which is typically after the defects notification period has expired. So the purpose of retention money is to secure the employer against defective work, and where a contractor fails to remedy defects, an employer can use the retention money then to cover the costs to remedy those defects. Liquidated damages is an agreed sum payable to the employer upon the happening or not happening of a certain event, such as a delay to the completion of the works. It is usually calculated at a percentage of the value of the contract per day or per week, up to a maximum percentage of the value of the work. When it becomes due, it's simply certified as part of the payment certificate as an amount due to the employer, and it can usually then be deducted from the monies due to the contractor for work done. It's enforceable as a liquidated sum as long as the event for which it provides actually did or did not happen as agreed. All right, then the types of securities provided to a contractor is significantly less, and typically it's a payment guarantee or a common law lien or a right of retention. So payment guarantee is also issued by a bank or financial institution to secure the contractor against non-payment by the employer. It is usually drafted as an on-demand guarantee on which the contractor can call when the employer fails to make payment due in terms of the contract. Sometimes it can be conditional upon the contractor having to actually prove that the amount is due. A lien or a right of retention. So the lien is a common law right to retain the property of the employer until the work that was done is paid by the employer. So you get an enrichment lien in respect of necessary or useful expenses, which is also known as a salvage or improvement lien. And it's limited to expenses which have maintained or advanced the market price of the specific item or project. Then you get a debtor creditor lien in respect of expenses considered to be more luxurious and which are restricted within the limits of contractual privity. So the common law right protects the contractor, especially where it does not have a payment guarantee from the employer. However, we see often, if not always, that this common law right is written out of the contract, although the counter to that is that the contractor then sometimes or most of the times gets an opportunity or a right to suspend work where it is not paid within a certain structural regime. Okay, moving over to the difference between an on-demand guarantee and a conditional guarantee, which is quite important. So an on-demand bond or guarantee acts as an independent instrument, creating a primary payment obligation. On-demand instruments impose primary obligations on the guarantor to pay in circumstances where the beneficiary makes the compliant written demand to the guarantor before the expiry of the guarantee. The purpose is to allow the beneficiary to immediate recourse to money and a secure source of money in case of a breach by the principal debtor, which is mostly the contractor, without being entangled in the merits of a dispute between the employer and the contractor. So the beneficiary, the one making the demand, does not first have to prove that there has factually been a breach of contract or prove the obligation in respect of which the on-demand instrument is issued, or the sum that is demanded, that the specific sum that is demanded is properly due. All that is required for payment to be made is proper demand, stating the beneficiary's compliance with the terms of the guarantee. And this is known as the autonomy principle. So that means performance guarantees stand separate and autonomous from construction contracts. The guarantee creates a separate contract between the guarantor and the beneficiary, and therefore not subject to the terms of an underlying contract between the principal debtor and the beneficiary. As such, the facts of any contractual dispute between the principal debtor and the beneficiary are not relevant to the question of whether a guarantor should make payment under the guarantee. A guarantor is not required, and in fact not allowed, to investigate the contractual terms or factual disputes to ascertain whether or not to make payment to the beneficiary. It only looks at the requirements under the guarantee. It will be obliged to pay the beneficiary, and it can only be interdicted from such payment where the principal debtor can show that the demand by the beneficiary was fraudulent. And we'll discuss that in just a bit. Likewise, the court will not be allowed to investigate the contractual position between the beneficiary and the principal debtor when determining whether a demand for payment under an on-demand guarantee is valid, as this would undermine the efficacy of such guarantees. This is different from a true guarantee or a conditional guarantee, which creates a secondary or accessory liability predicated on the default of the principal debtor. These guarantees have conditions attached to payment by a guarantor and are also referred to, as I said, conditional guarantees. The obligation to make payment is dependent on the beneficiary establishing a liability on the part of the principal debtor in respect of the underlying contract. So the liability under the underlying contract should first have been established in terms of the mechanisms provided for in that contract before payment under the guarantee would be enforced. So although the law on on-demand guarantees are clear, the principles are well established through jurisprudence, contractors still often approach the court to either interdict a demand by the employer to the guarantor for payment, or to interdict payment by the guarantor once the employer has already made a demand. We're going to quickly discuss the two types of applications and what the courts have said about it. So firstly, looking at interdicting a guarantor against payment under a bond, on-demand bond. So the only basis on which a contractor can successfully interdict payment by a guarantor under an on-demand bond is in the case of fraud, and this is known as the fraud exception. The fraud exception falls within a narrow compass and applies where the beneficiary, for the purposes of drawing on the credit, fraudulently presents to the guarantor documents or information that make, expressly or by implication, material representations of facts which are to his, the beneficiary's, knowledge untrue. The party alleging and relying on such exception bears the onus of proving it. And that onus is an ordinary civil one, which has to be discharged on a balance of probabilities, but will not be lightly inferred by court. In order for a contractor to succeed in respect of the fraud exception, it has to prove that the beneficiary presented documents or facts or made allegations to the guarantor, knowing at the time of so presenting to the guarantor that it constitutes a material misrepresentation of fact upon which the guarantor will rely and which the beneficiary knew to have been untrue. A mere error, misunderstanding, dispute, or oversight is not sufficient to amount to fraud, nor is it enough to show that the beneficiary's contentions were simply incorrect. So often in the interdict proceedings, the contractor as an applicant would raise facts of contractual disputes between it and the beneficiary, being the employer, in terms of the underlying construction contract in an attempt to show fraud by the beneficiary. The courts are, however, very clear that it would not investigate underlying contractual disputes between the parties in ascertaining whether or not a guarantor should pay out. It will look at the explicit terms of the guarantee and ascertain whether, under such terms, fraud can be proven. For example, that the beneficiary was not entitled to assert the essential prerequisite under the guarantee, viz. A contractor's breach. In order to avoid these types of arguments holding in water before a court in interdict proceedings, beneficiaries are cautioned against making a demand for payment under the guarantee unless and until it has complied with contractual requirements for doing so. So even though the contractual requirements are not relevant for payment under an on-demand guarantee, the beneficiary should not make a demand in circumstances where it knows that it has no contractual right to do so, as this could promote a contractor's argument for fraud. Moving over to interdict against demand for payment under a demand bond, which is significantly different. So beneficiaries should especially be mindful of any clear and specific contractual prohibitions placed on it for calling under a guarantee. So there have recently been quite a number of interdict applications in South African courts where principal debtors have attempted to interdict beneficiaries from making demands under on-demand guarantees on the basis that the beneficiary would breach a term of the underlying contract if it makes such a demand. It is accepted in South African law, contract law generally, that a party may interdict another party from breaching a contractual term. However, within the context of an on-demand guarantee being autonomous from the underlying contract, the courts are required to uphold the autonomy principle, and a breach of the term of the underlying contract should not readily be accepted by our courts in these types of interdict applications. So lately we've seen a drive for South Africa to start adopting the Australian and UK courts' perspective on this. They have accepted a second exception to the autonomy principle, being that a contractor may interdict an employer from breaching a contractual term when calling on an on-demand guarantee, although the courts have made it clear that this exception, being called the underlying contract exception, could only succeed in very limited circumstances. In Australia, the position is as follows. A building contractor may, without alleging fraud, restrain the person with whom he had covenanted for the performance of the work from presenting to the issuer a performance guarantee unconditional in its terms and issued pursuant to the building contract, if the contractor can show that the other party to the building contract would breach a term of the building contract by doing so. But the terms of the building contract should not readily be interpreted as conferring such a right. This is similar to the position adopted in the UK on the proviso that the beneficiary of a contract can in principle be restrained from making a demand under the bond if the underlying contract makes express provision for that. So although it's accepted in South Africa that an innocent party can successfully interdict another party from breaching the terms of the contract between them, the autonomous nature of an on-demand bond dictates that a contractor would not have the same right in an instrument which creates a relationship between the guarantor and the beneficiary only, i.e., excluding the contractor from the guarantee relationship agreement. The contractor cannot readily interfere with that relationship. So the underlying contract exception has not yet been accepted into our law, although there have been many judgments recently where this issue was considered. The courts have not yet been presented with a case where there was a clear and unequivocal provision in the underlying contract allowing for that principle, that underlying contract exception to be adopted. The most significant case on this issue is the one of ASJV versus Sanral, where the contractor argued that South African law should be developed to recognize this exception, so that if the underlying contract specifically restricts or qualifies a beneficiary's right to call on a guarantee, a contractor is entitled to interdict an employer from doing so until the conditions in the underlying contract have been met. The court looked at this and it found that the contractor did not demonstrate that the employer would clearly and unequivocally breach a term of the underlying contract by calling on the performance bond. And it found that the contractor cannot rely on implied terms of the contract to try and prove the underlying exception, underlying contract exception is part of our law. All right, so that's then it for securities. It's a handful, mouthful. I see that it is past 3. Betty, my suggestion would be that we continue until 3:30. Diana and I work through the questions that we already have in the chat. We'll answer them, and then tomorrow, after the session tomorrow, we'll do the same, answer all the questions as we go, and then have a proper Q&A session tomorrow. Okay, Diana, so I'm still on. Okay, so we're just going to quickly run through rights and obligations because most of what I'm discussing now has already been kind of discussed during the conversation today. So the rights that a party have depend on the type of structure, the type and the structure of a contract, but there are some basic rights that form the core of a construction contract, and that is really simplistic, that an employer has a right to receive a completed deliverable and a contractor has a right to be paid for that deliverable. When we're looking a little bit closely at a contractor's obligations, the most important general obligation that it has is to provide quality work, and this derives from the express wording of the contract. It derives from contractual documents such as specifications and drawings, and from quality management mechanisms such as the ISO specifications and legislation just generally. Included in this general obligation is a duty to warn, which is a principle that where the contractor does not design the work itself, it is nevertheless under a duty to let the employer know of faults or errors in the design documents. And this is measured against whether a reasonable and prudent contractor in its shoes would have and should have realized that there's an error or a mistake. And this is especially so where the employer no longer has a design engineer on brief to assist during the project. When it comes to materials, plant, and equipment, it's the contractor's obligation to ensure that the materials are suitable for the purpose for which they are used. Sometimes the contract documents will specify which type or brand of materials must be used, and the contractor is then bound to comply with those requirements. It cannot just simply substitute materials at will. The contractor also has an obligation to provide or source and to pay for necessary plant and equipment, although the cost of this will be included in the contractor's overall price of the project. When it comes to defects, all standard form contracts places an obligation on the contractor to remedy defects in the work that it performs, and we'll deal with that in detail separately. Then there's contractor's documents, which is typically it includes calculations, computer programs, software, drawings, manuals, models, technical documents supplied by the contractor for purposes of doing the work. So these documents are required by both parties to satisfy regulatory approvals and to ensure the completion of the work to be fit for purpose. So it may have to be in some circumstance, in some contracts, it may have to be submitted to the employer or its agent for inspection and approval before it forms part of the ultimate contract document. Safety, the contractor must observe safety legislation such as the OSH Act, Occupational Health and Safety Act, and an employer often also has its internal safety policies and procedures which the contractor must comply. So the contractor is responsible for safety of its site, so for as long as it's in possession of the site, for its work and for its employees. And then progress reports, whether they're daily, weekly, monthly, annually, it's a very powerful project management tool. And it's just the contractor would be required to accurately and truthfully report on various topics in these reports. So typically you'll see reports on actual resources on site, the progress of the work, risk items, which is often categorized according to the traffic light system. So yellow, green, so green being not a high risk, yellow, medium risk, and red, high risk. It'll include mitigation strategies, etc. So this is just a tool used by both parties to see where the project is actually at, identify risks, and properly manage the project work. All right, the general obligations of an employer, at its core, it's simply to pay for work done. And ancillary to that is to cooperate with the contractor and to ensure that it doesn't prevent the contractor from doing its job. It has to provide access to site, because without access to site, the contractor simply cannot perform the work. So although the access does not have to be exclusive, the employer is required to provide access to the site and to existing buildings, infrastructure for site establishment, performance of the work, for delivery of materials, for access to plant and equipment, etc. So it goes without saying that in most cases where the contractor does not have access to the site, there will be a critical delay to the work. However, where access is not given timelessly, the contractor could and should continue with its off-site activities, if there are any, such as design and manufacture, as much as it can to mitigate the delay. All right, then infrastructure and services is generally accepted to be provided by the employer. So this might include roads, electricity, water supply, etc. Although sometimes a contract might require the contractor to provide some of those itself and to price for that. Permits, licenses, and approvals, actually both parties' responsibility. So the employer would ordinarily have the obligation to obtain relevant permits, licenses, and approvals for a project. And these obligations, these obligations or a part of these obligations may, however, be transferred to the contractor, and the employer would then just have to assist the contractor with obtaining these. In any event, the contractor will also be obliged to assist and support the employer with obtaining any permits, license, and approvals where necessary, for example, by providing designs or other forms of documentation to the employer. All right, and then the contractor is likely to have its own requirements or its own scope of work for specific permits, licenses, or approvals, and those then have to be obtained, and where the employer needs to assist the contractor with any of those, or with documents or information to obtain those, it needs to do so. All right, that is just very short and sweet rights and obligations. All right, then we've got excuses of non-performance. So non-performance is typically a breach. And when I say when will non-performance not be considered a breach, I mean not be considered a breach for purposes of termination, so not an essential breach. So you have employer risk events, you have frustration, supervening impossibility, illegality, reciprocal duties and default, and repudiation. And then you also have force majeure. So typically those are events which would excuse non-performance, and we'll quickly run through each. An employer risk event, so standard form of contracts all set out events that are known as employer risk events. These are events which the employer will take the risk of. It may include war, rebellion, riots, use of the works by the employer, force majeure, etc. Employer risk events also include specific agreed events for which the contractor would be entitled to claim an extension of time or to be excused from performance, such as pandemics or epidemics, and like lack of access to site. The contract will specify whether the excuse from performance is automatic, which may be the case for force majeure and or whether it is subject to notice and particulars of claim from the contractor, which may be the case for lack of access to site, for instance. Then we're dealing with frustration and supervening impossibility. So the doctrine of frustration applies in the laws of England and Wales, and it's very similar to the South Africa's supervening impossibility. So where an agreement does not contain a force majeure clause, or if a force majeure clause in a contract does not name the unforeseen event that the parties wish to rely on, then the parties may be able to rely on the common law principle of supervening impossibility of performance, which will then suspend their obligations on the contract provided that it has become objectively impossible for them to perform the contract as a result of an unforeseeable and unavoidable event. The requirements to be able to rely on supervening impossibility is that the impossibility must occur after the conclusion of the contract. The event must be unavoidable and make proper performance of the contract impossible, and must not merely make performance more burdensome or economically onerous. If performance becomes objectively or absolutely impossible, the contractual obligation is extinguished and the duty to perform and the corresponding right to claim performance falls away. Objective impossibility includes instances of actual physical impossibility and also where performance remains physically impossible but cannot reasonably be expected to perform. So both parties' obligation to perform the contract will then be extinguished. In the event causing the impossibility was foreseen or foreseeable, and it could have been avoided, then the parties cannot rely on this doctrine to not perform their obligations. Once the force majeure event has come to an end and performance has become possible again, the contract will continue. The creditor will have the option to terminate the contract if the interruption is likely to endure for an unreasonably long time, and in some contracts, both parties would have that option. The question of what is an unreasonably long period of time is one of fact, unless it is specified in the contract. And in the event of the contract being terminated due to force majeure clause, certain financial obligations can still be applicable and could be paid at a reduced rate. Then moving over to illegality. So statutory illegality derives from prohibitions specified in legislation, while the common law illegality derives from public policy principles. Where a contract is illegal in its terms, the court may find either it to be void or to be valid but unenforceable. This is decided irrespective of the parties' agreement or conduct. In Siemens versus Prasa, the court confirmed that the doctrine of estoppel cannot render an agreement enforceable if it is invalid for illegality. This is particularly the position where it is in the public interest to ensure that an agreement is unenforceable. Where there is a specific clause in a contract that is illegal, the court can sever this clause from the contract and uphold the balance of the contract, but either void the specific clause or find it to be unenforceable. Where the performance under a valid contract will lead to illegal conduct, a party cannot be expected to perform such a task, and any instruction to do so would be unenforceable. Then, where there's reciprocal duties and a default by either party, the South African common law recognizes the principle of exceptio non ompleti contractus, where a party enforcing its contractual right has not himself performed, there is a valid ground for the opposing party to withhold its own performance. And that's within the idea of reciprocal duties. So some contracts deal with specific remedies for specific defaults by a party, and these provisions will override the common law and will then be the remedy available to an innocent party for default. As an example, FIDIC contracts entitle the contractor to suspend work or reduce its rate of work where payment is not received. However, it is subject to certain notice provisions. All right, then waiver. A waiver occurs when where the creditor elects, without discussion or arrangement, to waive certain claims or rights under the contract. It is, in other words, a unilateral act of abandoning a right that exists for the creditor's sole benefit. A waiver does not necessarily amount to a variation of a clause of a contract. It is a unilateral act by the waiver that does not require the consent of the other party, and there may be instances where an alleged waiver may in fact be disguised as variation, in the sense that it effectively results in a variation of the agreement. But in such case, the waiver must be in writing, especially if there's a non-variation clause. So waiver is the intentional and unequivocal renunciation or relinquishment of a known right. It's a matter of intention, determined objectively of the party said to have waived the right, and it's adjudged by its outward manifestation in the form of words, spoken or written, or in the form of conduct, or a combination of words and conduct. If a party does not expressly waive a right, and waiver is to be inferred, the conduct relied upon must be such as are more consistent on a reasonable view thereof with an intention to waive the right in question. The outward manifestations of intention must accordingly be judged from the perspective of a reasonable man in the position of the other party. So further, being matter of intention, election or waiver can only occur when the party concerned had full knowledge of the legal right which he is said to have waived, and of the facts under which or from which the right arose. So that's just in the sense that some performances can be waived either by conduct or express words. Repudiation, when one party to a contract without lawful grounds indicates to the other party, whether by words or conduct, a deliberate and unequivocal intention to no longer be bound by the contract, there would be a repudiation. It's not a matter of intention, it's rather a matter of perception. And that is the perception of a reasonable person placed in the position of the aggrieved party. So the test is whether such a notional, reasonable person would conclude that proper performance, in accordance with a true interpretation of the agreement, will not be forthcoming from the other party. So examples of repudiation include an express statement by one party that he is unable or unwilling to fulfill his obligations under the contract, conduct by one party that exhibits a clear and unequivocal intention no longer to be bound by the contract, such as abandonment of work or an unreasonable delay to performance, failure by one party to perform an essential term of the contract, and failure to comply with the court order for specific performance. Where there is a repudiation by a party, the innocent party must make an election within a reasonable time whether to accept the repudiation and terminate the contract and claim damages, or to reject the repudiation and claim specific performance. In Primate Construction versus Nelson Mandela Bay Metropolitan Municipality, the court held that if a contracting party repudiates a contract, the aggrieved party may elect to claim specific performance. However, should the repudiating party persist with its repudiation after the election is made and continue to show an unequivocal intention not to be bound by the contract, the aggrieved party may change its election and then terminate the contract and claim damages instead. So a party to a contract may be excused from further performance where the contract has been repudiated by the other party and the party elects to accept such repudiation. Force majeure, and we'll deal with that separately. Just very quickly, construction contracts generally do make provision for excuse of non-performance in the event of force majeure. Absent these specific provisions, the principles of supervening impossibility can be applied, as we've already discussed. So an excuse from non-performance is, however, not always automatic. Where the contract sets out specific processes or requirements to be complied with, excusing non-performance will be subject to such compliance. Okay, and then we'll quickly run through force majeure as the last topic for today. So force majeure can be described as those unforeseen events which fall outside of the control of both parties, impacting on a party's ability to perform, and which could not be guarded against or avoided by either party. The principal objective of a force majeure clause in a contract is to relax the obligations and to set a limit to the strict liability imposed on a party to perform in terms of a contract in the event of certain circumstances arising which prevent or have an effect on the party's ability to perform. So the general effect of a force majeure clause is that parties are excused from their obligations. This means that a party who validly fails to perform as a result of a force majeure cannot be held liable for any damages suffered by the other party due to this non-performance. So each of the standard contracts define and deal differently with force majeure events. But just as an example of force majeure, you have war and hostilities, riot, disorder, natural catastrophes, pandemics, or epidemics. It's not limited to the traditional acts of God type events. The effects of a force majeure, it might have an entitlement to time and cost, and it might have an entitlement to termination. An entitlement to time and cost is really regulated by how the contract allocates the risk. If the contract does not specify how to deal with the force majeure, the common law consequence will apply, and that is an excuse from non-performance for as long as the force majeure event exists. You'll see that in the standard form construction contracts, the force majeure is often, the rights under force majeure is often extended for a contractor to claim extension of time, and sometimes even to claim additional cost associated with such a delay. However, where it does not specify the time or the cost, the contractor will not be entitled to that, and it will merely be entitled to excuse of non-performance. The construction contracts often also entitle parties to terminate a contract where there's a prolonged delay due to events such as force majeure. So for instance, where a pandemic causes suspension of work for more than 180 days consecutively, either party may terminate the contract. And this really just allows the parties to mitigate extensive losses suffered due to delays on a project where it's impossible to perform. So termination can also be included as an automatic consequence of a prolonged force majeure, although typically it would be subject to notice of termination, i.e. election of a party. A party who elects to terminate must then ensure that it complies with the termination processes under the contract as they are relevant. Okay, and then with COVID-19, we have seen many people expanding the force majeure clause to specifically include known events, such as COVID-19. So after COVID-19, many contractors and employers found themselves without contractual recourse, and many legal minds looked into the legal position of common law recourse for the pandemic. This has caused many disputes between employers and contractors, mainly around the interpretation of contract clauses such as force majeure clauses, and whether they include a pandemic of the kind we saw during COVID-19. And it also caused a lot of debate around which common law remedies could be applied for something like COVID-19. So many lessons have been learned, and we now see pandemics and epidemics being included in force majeure definitions. Alternatively, we see COVID-19 and similar events being dealt with separately as a risk to be allocated between the parties. How the parties decide to allocate this risk will obviously depend on each relationship. Safe to say that it is important to ensure that your force majeure clause is properly drafted, properly defined, and properly includes or excludes specific events in accordance with the party's chosen risk regime. So force majeure could also be market sector jurisdiction specific. In South Africa, we have sector-specific risks, which we already ran through, which could fall within the broader definition of force majeure as it is drafted under standard construction contracts. It is important to deal with these risks specifically, whether under the force majeure clause or separately, in order to avoid a party taking on a risk which it did not anticipate or intend to take on. So a good example of this is the construction mafia that have caused many significant projects in South Africa to suffer and even to fail. So the construction mafia consists of local business forums extorting contractors to pay a percentage of the money they receive from a particular project to the forum. They are often armed and dangerous, and there have been reports of people, unfortunately, being killed on site by the construction mafia. In 2019 alone, at least 183 infrastructure and construction projects with more than 63 billion rand had been affected by these disruptions across the country. In Ramdale Cape versus South African National Roads Agency, the court found, however, that these disruptions was not a force majeure as defined under a FIDIC Red Book, because it was not completely outside of both parties' control. The court found that they could make an additional payment to avoid the risk. The answer may well be different if you look and apply this to another contract and the definition in other contracts of force majeure. But given the uncertainty whether it would be considered a force majeure and the significant impact it could have on the parties and the project, it's clearly a risk that parties should be aware of and properly contract for. And the same applies to any other risk that's market specific. Don't just leave it to be dealt with under the standard form contract and hope that it fits in somewhere. Foreseeability in force majeure. So the definition of force majeure is important to ascertain whether foreseeable events, whether that is outside of the control of both parties, would be a force majeure. Again, the construction mafia could be used as an example. So here, parties now know that it is a prevalent event in South Africa, and therefore it may not always be a force majeure event because the definition specifies that events that was or ought to have been foreseen would be excluded. Specifically under common law, the definition of force majeure is premised on the event not being foreseen or foreseeable at the time of contracting. And you'll find the same contract term or premise in most of the standard form contracts. Lastly, ability to avoid, guard against, or even mitigate force majeure. A contractor always has the obligation to mitigate delays and losses as much as possible. Properly drafted force majeure clauses will allow both parties to work together to avoid or mitigate losses for force majeure. All right, so I think we'll call it a day at that. Diana and I will work through all of the comments, all of the questions that we got. I will send those on with answers to Betty sometime tonight, and then she can just distribute that to all of the participants so that if any of the questions remain unanswered, you can pop it into the chat box tomorrow. And yeah, we'll then continue with the program tomorrow and have a proper face-to-face Q&A session after.
Thank you, everyone.
Thanks, guys.